Hey, yeah. I've got a little bit of a voice that booms, and so I haven't learned how to moderate it yet. Thank you. Hey, I'm sorry. Yeah. Anyway, it's a real pleasure to be out here with y'all today. Frankly, we can talk whatever y'all want to talk about. When Matt called me, and actually John called me and started asking, would you mind come out and speak? I said, sure. What do you want to talk about? He says, how about give us a history of the Constitution? No. I am not a historian, okay? I'm an attorney who's been practicing law for 35 years. I started out, bless you, whoever that was. Bless you. I had a lady who did that 3 times in a row. I went to school with her at St. Gerard's on the east side of town, and it was always in threes. So, one more? No, okay. But I said that I'd love to come out and talk to you all about what we do in our everyday lives as judges in terms of the Constitution, because I seem to have a feeling that sometimes people think about the Constitution as this document up in Washington in the archives, and we talk about it in lofty tones and really never understand that it's all around us. And it's not just the Fourth Amendment, and we can talk about the various amendments if y'all want. But it really is all around us, and we have to utilize it and apply it every day. And notice that I said apply, because I really think that when people say they interpret the Constitution, I get a little nervous because the words are fairly plain. But the problem is that the devil's in the details, is that we may not always agree what those terms mean. So, it's a circumstance that that's what I'd like to discuss with y'all today, is kind of like what we do in our courts and how we apply the Constitution. I hope y'all have questions, because frankly, instead of me droning on here for about 15 or 20 minutes about a topic y'all would not care to hear about, I would much rather answer any questions that you have. So feel free to interrupt. $5 to the first person that does it. Oh, no, I'm sorry. You work here, you can't do it. It's not apply. So you can't do it, but we'd love to go at it that direction. All right, how many people here love the Constitution? Yeah. How many people think that it was a crying shame what happened in Casey Anthony trial? I thought you loved the Constitution. And I kind of talk about that because the reality is that while we talk about the 10th Amendment, thank God, we can, tell the government that the states retain certain rights, and I believe that that's what the Constitution does. That is, it puts limits on the federal government, and I believe that's very important in our lives. When we get down to individual cases sometimes, people think, well, that's stupid. I used to love to voir dire jurors. Like I say, I practiced 30 years as a criminal attorney. No, that doesn't mean I was convicted of crimes. I mean I practiced in the criminal law area. 15 as a prosecutor, 15 as a defense attorney. I started out as an assistant DA, did that 4.5 years here in Bexar County, federal prosecutor for 3, back out in private practice for about 6 years, ran for district attorney, was the first Republican elected DA in 1990, served 2 terms. After that, well, thank you very much. After that, decided I didn't want to do a 3rd term, went out and started a private practice. Judge Bill Sessions, William Sessions, the former director of the FBI, saw me at a grocery store one day, said, what you doing, Steve? He knew me when I was a federal prosecutor. I said, Judge, just enjoying life. And he says, come on down. We have a place for you at our firm. So I started doing some civil law with his firm, and then in 2006 decided to run for the 4th Court of Appeals and got elected and been serving since then. I'm up in 2012. The 4th Court is a state court, all right? So that means that we hear appeals from 32 counties involving state, civil, and criminal matters. Half of our cases are criminal cases. Yet we apply the United States Constitution often because whenever somebody raises a constitutional claim, wait a second, the police did not have a warrant to come into my house, and so therefore I'm challenging the right of the state and the government to use that evidence. They can raise it either under state constitutional grounds or federal constitutional grounds. But most of the time, people just rely on the federal Constitution because, for most parts, our state Constitution has been interpreted to mirror what the federal Constitution does. So that's why we get there. When I was talking with Mac, in fact, we were talking about the Fourth Amendment, and how many people here believe that the Fourth Amendment requires the police to have a warrant to come into your house? Nobody? Oh, you started to raise your hand. I appreciate it. All right, we got an honest guy out there. Actually, it does not. If you read the Fourth Amendment, and I have my pocket constitution here, it doesn't even indicate that there is a preference for warrants, but people have interpreted that way. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So what you see is that the Constitution really says that, well, you can't be the subject of an unreasonable search or seizure. And that's where, again, arguments occur every day. We have, for instance, a case in front of us right now. A Child Protective Service officer or investigator goes out. He heard that marijuana is being used in front of a 6-month-old child at a certain location. Goes out, he's looking for the mother, knocks on the door. This man answers the door, kind of cracks it a little bit, asks where the mother is. She's not here. Asks where the kid is. He's not here, or if she's not here, the child's not there. He leaves. Smelled a strong odor of marijuana. He calls his supervisor. Supervisor says, call the deputy sheriff, because it was out in Bexar County. Deputy sheriff accompanies the guy back over to the house. About an hour later, deputy sheriff is standing to the side of the person. The investigator knocks on the door again. As the door opens, the deputy sheriff says, I smell a strong odor of marijuana. He goes into the house with his taser drawn, seeks compliance of the individual. The individual complies. At that point, I think starts crying. The officer asks for permission to search. The individual signs a consent to search, and they find marijuana in a backpack. Gets prosecuted for marijuana. At trial, the argument to the trial judge is that the police didn't have a warrant. Therefore, it's an unreasonable search and seizure. Trial judge overrules it. What do y'all think? Anybody got? Somebody shaking your head? Yeah. You disagree with what? I didn't say which it was. Uh-huh. And why is that? I'm sorry. Now we're going to get you on film in a second, too.
Okay. I do not believe that they had the right to come in just strictly on the odor of marijuana.
I see.
First of all,
Okay.
I don't think that that was a proper. And for her to go back and get the deputy sheriff and he to come back again without a warrant, if he had felt that her smell, her sense of smell was so good that he felt there was something going on, then he should have sought out and had a warrant to come in. And then when he comes in and he asks the man, you know, did the man give permission? I did not hear.
He eventually gave consent to search.
But based on what did the
cop
deputy
asking.
say?
The deputy asking politely. Let me jump ahead a little bit here, and I understand you bring up two good points. The United States Supreme Court, in interpreting similar situations in past, have said that you need two things to go into a house without a warrant. First, you need probable cause, and then you need what's called exigent circumstances. And exigent circumstances often are like beauty in the eye of the beholder. And so that's what the case will center around in terms of whether or not the smell of marijuana alone would equal probable cause, and then whether or not exigent circumstances exist. And what's kind of interesting is that you mentioned the point about, well, wait a second, if there was probable cause, assuming that the smell of marijuana is probable cause, he should have just went and got the warrant. And Mac and I were talking about a recent case called, Mac, help me out, is it Kentucky versus King?
Kentucky versus King,
Kentucky versus King, United States Supreme Court, 2011 of this year, May of 2011, excuse me, where the Supreme Court reiterated its earlier decisions that you don't have to stop your investigation. In other words, as soon as you have probable cause, you don't have to stop your investigation. You can continue it forward. You're not required to go get a warrant simply because you have probable cause. And so, you know, again, I appreciate your sense of what ought to be, but these are the sort of decisions that are going on a daily basis that affect y'all's rights. We had one that came up before the court. We didn't get to issue an opinion on it. Does the Bear Appraisal District have the right to come inside your house when they're doing an appraisal of your home? How many people think they can? How many people think they couldn't? Yeah, well, you know, it kind of depends, and I'll leave it at that. We didn't have to issue an opinion, but that does come back to the Fourth Amendment because it's an entry into your home, and the United States Supreme Court saying that entry into the home is, in essence, a search of the home. Competing interest, and again, devil's in the details. If the homeowner says, my home should be valued less because the inside of the house is a total mess, then you can understand, well, maybe having the government come in, and check out the inside of the home would not necessarily be an unreasonable search at that point in time because the homeowner is putting that controversy into play. So, again, things like that. I know I've been talking about criminal law. You got a question? I got $5.
The individual had refused entry when they first came to the door with the deputy, and they asked to come in, and the homeowner says, no, not now. What could they have done, or what should they have done?
Well, I'm going to change your facts just a little bit because the testimony was at that trial that nobody ever asked permission to come in. As soon as the deputy smelled the odor of marijuana, well, I ain't saying it's sufficient. I'm just saying that's when he acted and said, I'm going in. And I think there was some trial testimony about he was worried that the evidence would be destroyed. It is interesting in this case, Kentucky versus King, I think it was Justice Alito that was writing the opinion and talking about what does equal, well, not really what does equal exigent circumstances, but you take certain factors into consideration. For instance, there was a body of law that was talking about, well, if the police know that they're going to find that smell there, or they know that when the door opens they're going to see the dope, then they're kind of creating their own exigent circumstances. And Justice Alito was saying, no, not really, because if the police are doing what any other citizen can do, then why does the Fourth Amendment or any part of the Constitution put limitations on their behavior? So if a salesman can go up and knock on your door, then a police officer can go up and knock on your door, regardless of what knowledge he had before. And in fact, Justice Alito had a passage in the opinion, I can't quote it verbatim, but it's something like, people would probably be reassured when they see it's a police officer on their front door. And I suggested on the TV show, on the radio show yesterday, that I'm not sure he lived in the real world. I'm not sure how many people are reassured. And if there's any police officers, don't take offense. I love you guys. I'm just simply saying that people associate an officer's knock at the door usually with some bad news. You know, somebody got hurt in a wreck or something else is going on. And so, again, to answer your question, it kind of depends. If the person opens the door, in other words, you knock on my door, you're in your full uniform, I open my door, and right behind me you see 200 bales of marijuana. The smell is overwhelming. And as a narcotics expert for the past 35 years, you know what marijuana smells like, looks like, is packaged like. Again, the courts have kind of said, well, it would be unreasonable for the police officers at that time to close the door, go get a warrant, because what's going to happen by the time we get back with that warrant? That stuff's out of there. And so that's kind of the nature of the exigent circumstances. It's the courts balancing what they think constitutes a reasonable versus an unreasonable search. And what's interesting, too, is I heard a constitutional law expert, I'm not, all right, But someone who proclaims himself as a constitutional law expert talked Friday up in Kerrville, and he was saying that the courts don't base decisions on the Constitution anymore. They base them on past court decisions, what we call case law. And I disagree with that, because as a practicing judge, no, our decisions are based on the Constitution. But now what we do, sometimes if a fact situation has been looked at in the past and examined in the past and held to be a reasonable search, well then sure, sometimes what the judges do is cite back to that case as a shorthand. Because why go through all the explanation that was in that case to just come to the same resolution? So that's what's called case law. And again, I was up in Kerrville a couple of weeks ago talking with a group, and somebody asked the question like, well, why do we have this case law? If we have the Constitution, then isn't that all we need? And the answer is, again, the case law comes about by prior acts of the court interpreting those situations. And then you tend to go along with those unless somehow the Constitution is re-examined in a different light. Yes, sir.
Just one question. I'm not saying I'm either for these or against these, but here in San Antonio and all across the state, we have no refusal weekends for DWI. You're talking about Fourth Amendment, reasonable search and seizure, but we're also guaranteed by the Fifth Amendment the right to not incriminate ourselves.
Sure.
How is it that they're not using the Fourth Amendment to violate the Fifth Amendment by forcing you to incriminate yourself and things like that? I'm not saying I'm for them or against them.
No, I
I'm just
understand.
asking that.
And I guess everybody heard the question, right? Okay. Well, the answer to that is that the courts have held that the Fifth Amendment talks about communications. So in other words, if I'm trying to get somebody to tell me where a person is buried and they won't tell me, so I pull out a fingernail and that person says, okay, I'll tell you it's such and such place. That's a communication. The courts have held that things like your fingerprints are not communication. They don't say anything. They're just there or not there. And so going to the no refusal weekends and the Fifth Amendment of privilege against self-incrimination, what the police officers and the DA's office has done is to say, well, we think that there is evidence of a crime, and that evidence of a crime is at a particular location. And so they then attempt to comply with the Fourth Amendment by getting a warrant that establishes probable cause that a crime was committed, the crime of DWI, and then they attempt to establish that probable cause exists to believe evidence of that crime, alcohol, is found at a certain location, your body. And so if they comply with that, the Supreme Court has said, in a different situation, that the police have a right to get that search warrant and have a right to come into your body. Now, I know some lawyers that'll talk with me about that, and they say, well, they can't do that. What if I refuse? Okay, let's go back to my 200 pounds of marijuana. They go get a warrant instead. They put a guard around the house, make sure I don't take it out. Go get that warrant, and they comply with the conditions of the warrant, come back to the door, knock on the door, and say, hi, we got a warrant. We're coming in now. And I say, gee, no, you're not. I mean, again, most of us would think, well, no, they're coming in. Same situation with regard to the blood draw. Once they have that warrant to draw your blood, they're coming in. So I don't know if that answers the question. How about we got, yes, sir, in the back. Oh, I'm sorry, right here. He's got a microphone. I apologize.
Thank you. I'm curious to go back to the case with the marijuana. Wasn't the social worker who came to the door, she was the first one. She was there specifically to check on a baby.
Right.
Now, wouldn't that, nobody has mentioned this, wouldn't that in itself warrant the detective not to have to worry about getting a search warrant? That would be a very important thing to walk into that house. There's an endangerment of that child.
Well, and you bring up, there are several exceptions to the warrant requirement. One of the exceptions is exigent circumstances. One is, some people call it a community caretaking function. Other people call it an emergency doctrine function. And that is, for instance, if you call up the police and say, hurry up, there's a man in my bedroom and he's got a gun on me, okay? we all agreed that the cops probably don't need a warrant to come into your house. You've kind of invited them in there. Or let's say it's not your home, but it's somebody visiting you, and you're getting in a fight with them, and same sort of thing. They call the police, and it's your home. You know, they're there by your permission, but they call the police and say, hey, this person's about to shoot me. Police are coming in without a warrant under this emergency doctrine. So there's about 3 different exceptions to the warrant requirement that have been identified by the courts so far, and that would be true. But under the facts, there was not any indication that the child was in emergency need of help or was under some sort of emergency situation where immediate harm was being done to the child. Microphone's in the back, I think.
Yes, sir. The establishment of case law, what allowed it? Because everybody uses the separation of church and state. That at the time that it was implemented, it was a single judge's opinion that came up, and there wasn't anything that substantiated it. So what allowed case law to become rampant as it is today?
Well, let me kind of go back a little bit, and then I'll get to the answer. I'll do a politician thing here and get to the answer. Hey, come on, man. You know, y'all said you were going to treat me nice. Yeah, okay, yeah. Are my lips moving? I'm sorry. If my lips are moving, okay. The neat thing about our justice system is what you kind of maybe described was one man's opinion. In other words, you go into trial court and you sue, or you're trying to get something overturned or something declared unconstitutional. It just takes one person's opinion, in essence, to get that done. Now, when you move to the higher courts, in our state system, it's the Court of Appeals. There's 14 of the courts spread across the state. Like I say, my court covers 32 counties, going all the way down to the valley at Starr County, all the way up the Rio Grande to Laredo del Rio, then all across the hill country, Bernard, Mason, Sutton, Junction, Kerrville, back into San Antonio. At our level, it takes anywhere from 2 to 5 judges to say, okay, we agree with that lower judge's opinion, or we don't agree. And then when you get to the highest courts, either the Texas Supreme Court, the Court of Criminal Appeals, because in Texas we have specialization at our highest courts, or the United States Supreme Court, it takes 5 people to agree with whatever proposition it was, either to reverse the lower judge or to affirm what the lower judge did. And you know, I never really thought about that before, but the idea that we start looking for collective wisdom. You know, we're not always going to get it right. You know, the Dred Scott decision saying, you know, that slavery was constitutional or slavery was okay, you know, that certainly got reversed and overturned. So they don't always get it right. To your point about case law, what case law does is that it establishes a principle of precedential value that in essence says that if you as a court have made this decision in the past, then you will continue to apply that same result under similar fact situations until a majority of that court says not to. And I'm talking about the highest courts, so like the Supreme Court or the Court of Criminal Appeals or the United States Supreme Court. So that's how they get there. Again, it's a shorthand resolution because in essence, you don't want people ping-ponging all over the place on the same fact situation. You want some of that consistency, and so that's how case law comes about. And he wants the microphone back. He has a follow-up question. But it's just, hang on for a second, I'll get to you. But again, it's just the shorthand way of saying we've already determined that, and so we don't need to re-examine that unless it comes about for a particular reason. The United States Supreme Court in about, 4 or 5 years ago issued a decision called Crawford that deals with the Sixth Amendment right to confrontation. We have a long historical use of hearsay in our courts. You always hear hearsay is not admissible, but it can be. I have to wrap it up. I'll get going real quick. But it allowed people to use hearsay in the courts. Supreme Court had no problem with it until, like I say, about 5 or 6 years ago. Crawford came out and they said, wait a second, this hearsay violates the Sixth Amendment. And so all the previous opinions of the court where that was admissible now are no longer good, and we've kind of changed directions. Do I have time to let him answer the one question? No.
No, but
I am out of time.
If you want to make yourself available after the meeting for more questions.
No, sir. I'm totally against my religion. No, I'm teasing.
The justice will make himself available after. We'll lock the doors.
But I don't want to disturb the rest of the meeting. I'll kind of go in the back. We can go outside or something like that if y'all want to do that.
Wonderful.
But anyway, thank y'all very much for letting me come in here and talk with y'all. I really appreciate it.